How are you? Are you well? Fine. Is your mic on? I can barely hear you.
I think it's on now. Chief
That's
Justice.
better. Okay. Are you ready? Can you start?
I think I am.
All right. What do you mean you think you are? Okay. You hold a BProc degree from the University of Witwatersrand, which you acquired in 1986.
Yes, 1986 I got my BProc degree from Wits University, Chief Justice.
And your legal career started around that time when you registered your articles.
Yes.
And you were admitted as an attorney when, in 1989?
In July of 1989, Chief Justice.
And went on to become a professional assistant, then went through the ranks, rose all the way up to partner.
Yes, that's correct, CJ.
At which firm was this?
Well, I became an associate and then a partner at Lindsay Keller in Rosebank, Johannesburg.
And you started with them in 1991 already?
Yeah, I started off in 1991 and I stayed with them until I was elevated to the bench.
How long were you with that firm?
It's approximately 26 years, CJ.
Doing what kind of work?
Well, I was involved a lot in insurance law, but I also had a general practice in, towards the end of my practice. I was very much involved in the Road Accident Fund in addition to being involved in other type of commercial type of litigation, CJ.
By the time you left, you were managing partner?
I was the managing partner at the time I left and had been for about 10 years.
And you were appointed to the bench in January 2017?
Indeed.
It's been a while. All right. You've acted at the Electoral Court since when? November 20...
For exactly 1 year, CJ, from November 2023 to the end of October 2024.
So you were in that court during the run-up to last year's elections and during the heat of the elections themselves?
I was in the middle of all of that, CJ, yes.
How was that experience? We only got a few of the cases that had passed through your hands, and it was quite hectic for us. How was it at the Electoral Court itself?
It was extremely hectic, especially during the months of May. In fact, maybe also the months of April, May, and June. Those were the hectic periods and the times when we really felt the heat.
Yeah. And did you get an opportunity to write any judgments during that period?
Yes, I did, CJ. I wrote quite a few judgments.
Okay. Were you able to deliver your judgments within reasonable time?
Well, most certainly, CJ, we were required, obviously, to deal with those matters on an urgent basis, and we ensured that judgments are delivered within a week, 2 weeks from the date that we heard the matter. In some cases, we even decided the matters on papers without hearing the parties.
Yeah. You have listed a few articles you published, that were published during your time as an attorney.
Yeah.
Just tell us a bit about those. What subjects did you cover?
Well, the one I recall offhand, CJ, related to the retirement age in the context of labor law, and what one needs to agree between yourself and your employee, lest you be prevented from asking that person to retire. And the other one related to the abuse of power by Metro Police in the Pretoria area at the time. So those are the two articles that I wrote.
comes easily to you. And I imagine you don't struggle to write judgments.
I think so, CJ. On the last occasion, I indicated that I had written in excess of 320 judgments which were published.
Yeah.
They've now increased to just under 400 published judgments. So I would have written in excess of 400 judgments since I was elevated to the bench.
Yeah, that's a huge output. How many judgments have you written in the Electoral Court? An estimate will do.
I think it's about 4 or 5 or probably 5 or 6, CJ.
Well, I know it's early days yet, but do you know if any of them have been taken on appeal?
Well, there's the one that was taken on appeal is the Labour Party judgment that went to the Constitutional Court. That was upheld. My judgment was upheld by the Constitutional Court.
All right. You have declared certain health issues that are very common, and I I do empathize with you because I am in the same boat myself. Does your medical condition hamper your work at all?
No, not at all, CJ.
You manage it?
Yeah, as I indicated to you on the last occasion, I'm on medication for my hypertension and cholesterol. I think it's under control. I see my medical practitioner on an annual basis, and he gives me the assurance that I won't drop dead soon.
I do hope that you follow a healthy lifestyle, because that's more important than the medication itself.
Yeah, I most certainly do. I most certainly do, CJ. Yes.
All right. No, thank you very much, Judge. I'm going to hand over to... welcome, Justice Zondi, Deputy President Zondi.
Thank you, CJ.
You may take over.
All right. Thank you. Good morning, Mr. Adams.
Morning, DP. Nice to see you.
How are you this morning?
Okay, thanks. I hope you are too.
Yeah. I see that in your questionnaire you indicated that we had about 4 judgments outstanding. What is the situation now? Have you tried to clear them out?
No, I've handed down all of those judgments, TP.
Okay.
Yeah.
Well, I must just record that I never had a problem with you with regard to the delivery of the judgment at the Electoral Court. The judgment that I assigned to you, you dealt with them expeditiously, and there was no issue with regard to the delivery. And hopefully, should you be appointed, I'm definitely sure that we'll continue to contribute to the Electoral Court.
Yes. Thank you, DP. Yeah.
That's all that I wanted to say.
Yes. Thanks, DP.
Thank you, CJ.
Candidate colleagues. Minister.
Thank you very much. Good morning, CJ. And let me just welcome Judge Adams and wish you well in this process. Let me just start by asking, in 2015, the Constitutional Court criticized you for failing to inquire to the relevant circumstances of the evictees at that time, refusing to rescind the original eviction order that was erroneously granted. And in this, because I'm just, as you know, I'm former Minister of Human Settlements and would have had to deal with the plight of those that are evicted when they are evicted, a majority of them being women and children. In that regard, and I do believe that this would have put this vulnerable group at risk in terms of not being able to be having a shelter over their head. Do you regret this decision that you took and your exercise in terms of good judgment in this regard?
Yes, thanks for the question, Minister. As indicated, I think, by the GCB, that judgment was handed down very early on in my career on the bench. I was acting at the time, firstly. And secondly, I most certainly have learned from my judgment. In the context of the development of the law at the time, I clearly erred, as was held by the Constitutional Court, and with the benefit of hindsight, I definitely will deal with the matter differently now. The matter was referred back to the Johannesburg High Court, and I'm told that subsequently that matter has been resolved favorably in favor of everybody, including the owner of the property.
Thank you very much. I think the next one that I have, just last one, CJ, it's around the modernization of the voting system. That IEC would have announced that investigating electronic voting to modernize South Africa's elections. And some have argued that there are what e-voting offers a wide range of benefits in terms of that. But there are also those who are arguing around the downside of the digital electoral process. Issues such as tampering and not making sure that there's actually the right to vote by many, especially those that are in rural areas, but also potentially of ensuring hacking of the systems, cyber crimes that could lead with tampering of the votes and democracy in our system. What is your perspective in this regard in terms of the integrity of our electoral system by the introduction of digital platforms or digital voting, and whether that could tamper with the right to vote or even one vote, one citizen across the country?
Yes. Thank you, Minister. I think it's inevitable that at some point we need to progress towards digital and e-voting, but we must obviously be alive to the risk involved. I think the Electoral Commission has commenced the process in the registration of parties and candidates, must be done electronically, but they have also retained the option to do some of these processes manually. I think there are risks involved in the digital voting process, but I think similarly it has its advantages, and maybe that's ultimately the way that we should progress.
Minister, any more questions for the candidate colleagues? Professor Marumachai?
Thank you very much, CJ. Good morning, Judge.
Morning, Prof.
Judge Adams, I want to ask you a question. I think in the last round of interviews for this court, one thing that concerned me, not in relation to you, but generally, was that it appeared to me that there were some candidates who were not quite familiar with the recent developments in the electoral law or election law, as perhaps you put it in your question. I just want to ask you, I want to satisfy myself that you have been acting for a year, that at least you are vested in the development. I'm not sure if you are aware of the amendments that were done in 2003 to the Electoral Act, and some of the requirements in relation to candidates who want to stand outside the party political structures, and some of the concerns that they had. I want to find out from you, what were the major concerns and how did the Constitutional Court try to address those issues?
Yes, thank you, Prof. I think that the main concerns that the independent candidates had related to the requirement that they needed to have a 15% of the quota of voter supporters to just get onto the ballot, so to speak. And they thought that that was unfair, firstly vis-a-vis the fact that they don't have the necessary capacity to do that. And in fact, they had to do it. If you're going to be standing in any particular province, you needed to get 15%, and which 15% of voter supporters of the quota from the previous elections. So in certain instances, for example, that would have required them to get about 14,000 signatures, names, identity numbers of supporters. And so the Constitutional Court agreed with the independent candidates and said that that seems unfair, and they reduced that and said that all that they need is 1,000 voters for each particular province or each region that they're going to be standing in.
Thank you, Prof. Commissioner Malem?
Thank you very much. Judge, just a follow-up on the last question. What mechanism can we put in place to verify that these 1,000 signatures are authentic? Because they are not being audited some anyhow. We just get a name, surname, correct ID number, and then you sign or get different people to sign for other people. How is that helping us if it cannot be somehow verified that these are authentic signatures?
Yes. Thank you, Commissioner Malema. In fact, that was exactly the difficulty that the Electoral Commission had in the Liebenberg matter. I don't know if you're familiar with the matter, but it's Liebenberg versus the IEC. Mr. Liebenberg intended standing independently in some of the provinces, and the Commission has systems in place that is able to verify, firstly, the ID number. They connected somehow to the Department of Home Affairs, so they were able to make the connection and see and verify, firstly, the identity number. And then, so if it's a non-existent identity number, it's thrown out automatically. And then they also have a way of establishing the residential addresses of these persons, and that they got from their systems that indicated that a particular person is registered in a district. And in this case, for example, in Limpopo, when there was an attempt to have them used as a supporter in Mpumalanga. And so they were able to pick that up, and ultimately they then also had investigations done in respect of certain individuals who then confirmed, for example, that they were not the ones that signed those lists of matters. So they were able to siphon out all of the fake, so to speak, signatures. I don't suppose it's foolproof, but it's at least a start, Commissioner Malema.
Judge President Mlambo.
Thank you very much, CJ. Good morning, Judge Adams.
Morning, JP.
Good. You have the title of the resident dean of the faculty at the High Court in Johannesburg. Could you tell the Commission why? Shortly, not very long.
Yes. Thanks, JP. It's a title that you've bestowed on me, JP. The reason for that, I'm assuming, is because I'm a member of the Continuing Judicial Education and Training Committee at the Johannesburg High Court, and I convene training sessions on a weekly basis for judges to enhance and advance our skills. And so that's where that comes from. So I would ask other judges to present on topics that is topical at the time, so that we don't fall behind in our education and our skills development. So hence the Dean of the Johannesburg High Court title.
Thanks for that. And I can tell you, acting judges in particular value these sessions. One, I just want your comment. We're battling with backlogs in the high courts and in other courts. And some jurisdictions, like China, when me and the CJ visited them, we found out they were using AI judges. Please find time and schedule a session where we discuss whether we could use AI judges to deal with these backlogs. I don't want to comment.
Yes.
Thank you, CJ.
Thank you, JP.
Thank you, CJ.
Commissioner Pillay?
Thank you, Chief Justice. Good morning, Judge Adams.
Morning, Commissioner.
Judge Adams, I just want to follow up on the question posed by the Minister in relation to digitalization. And I want to tie it into your judgment in the Labour Party matter, which concerned the online candidate nomination system of the Electoral Commission, and whether or not the Commission was entitled to rigidly enforce its timetable for the uploading of candidate lists and supporters lists onto the system. And you had found that the system was fit for purpose and that the Commission was entitled to rigidly enforce it. The minority judgment in that matter raised the question of the digital divide and its impact on inclusivity and its impact on people being able to exercise their right to participate in the electoral process. Now, do you have a comment on that? Because you don't see that reflected in your judgment, considerations of the impact of the digital divide.
Yes, thanks, Commissioner. I must just say that the Constitutional Court agreed that with the approach adopted by the majority judgment, which was my judgment, firstly, and then secondly, I did not mention specifically the digital divide, except that I said in my judgment that the difficulty with the complaints on behalf of the applicants in all of those matters were that they clearly had not done the necessary preparation in order to ensure that they comply with the requirement relating to the uploading of the list. So it wasn't so much the fact that they didn't have the necessary skills, they just did not have the necessary, they didn't do the necessary preparation, and they started their uploading, for example, at a very late stage, which left them vulnerable, and ultimately that is the reason, and like I say, the Constitutional Court agreed with me, but it wasn't a case of them being disadvantaged as a result of the lack of technical knowledge or technological knowledge.
The only issue, Judge Adam, is that your judgment went beyond the facts of that particular case, because you said ultimately, I think you made a finding that the online portal system was fit for purpose. And I think in that context, the minority comes back and says, well, in making that finding, you need to consider that there may well be people who don't have access, and this may impact their right to participate in the political process.
Well, the answer to that again, Commissioner, was that there were alternatives available to political parties and candidates who could, for example, submit their list with the supporting documentations manually. Unfortunately, it was at the office of the Electoral Committee in Centurion at the time, but there was that alternative available to them.
Thank you, Chief Justice.
Thank you, Commissioner Pillay. President Mulemela.
Good morning, Judge Adams.
Morning, President Molamela.
Yes, I've noted that some of your court proceedings take place virtually. Is that correct? For the Electoral Court?
Yes, yeah. In fact, most of our hearings were held virtually.
Yes, yes.
We just had the one. No, sorry, we had about 3 of the ones that the important judgments or matters we had in person, but the balance were all held virtually.
Yes, I'm interested in that, your own personal experience. Did it work out well? Were there any challenges? Bearing in mind that you always sit in panels in the Electoral Court.
No, President Molomela, not just from the Electoral Court, but since COVID in our court, we've been doing virtual hearings, and I think we have fine-tuned the process of virtual hearings, especially in our division. I've conducted a few trials virtually as well, and even with the load shedding at the time, we had experienced very little challenges relating to the fact that these matters were being heard virtually. In fact, some of those matters have subsequently gone on appeal, and the record, I'm told, is a lot easier to transcribe than is normally the case. So, the short answer to your question is that I can't complain of any challenges that we've experienced, especially not during the hearings in the Electoral Court.
Thank you, Judge Adams. Thank you, CJ.
Thank you, President.
Thanks, President.
More questions, colleagues? None? All right. It appears that we've reached the end of your interview, Judge Adams. Is there anything you wish to raise with us before I release you?
No, just to thank the Commission for hearing me yet again for the third time.
Well, thank you for not giving up. You're excused.
Thank you so much, CJ, and thank you all the commissioners.